Yes, my brother. Thank you very much. But I want to confirm one thing. Where was the committee given a timeline within which to operate? Can we confirm that?
We don't know about that, and generally Article 146 does not provide timelines. Yeah. Perhaps that is the reason when you were passing the Special Office of Special Prosecutor Act in 2017, you put in there that there should be timelines, so everything is time-bound.
So in the absence of timelines, what was the committee in a hurry for? Why the rush? Particularly because you have two other petitions, so to speak, quote unquote, and I'll address all those pending before you. Why? Who was putting pressure on you to achieve what? When you are dealing with a matter as important as the removal of the Chief Justice of the Republic of the land. Why were you in a hurry to present your report on just one of the petitions, right, which in your view would then dispose of all the matters and will make other petitions redundant? Couldn't you have taken your time to receive the address or submission of the Chief Justice? Doesn't fairness dictate it? I thought that this is not a commission of inquiry. Right? It's also not, even though you are using CI 47, even with CI 47, Thompson, how many times doesn't the court adjourn just to take our addresses? The court adjourns on many occasions. Sometimes, even when the court has fixed the date for parties to file their addresses, you can come in with an application that may impact the filing of the address. And so the court, in hearing the application or having disposed of the application, will give a new date to the address. And so even under the CI 47, there is always enough room for the court to entertain such request for adjournment to receive or to file addresses.
But that's obviously discretionary, right?
Yes, but I would think that when you are dealing with a matter of this nature, you should be predisposed to a lot of laxity to accommodate, the Chief Justice, particularly given the sensitivity of the matter that we were dealing with, the sensitive nature of the matter which they were dealing with.
You think 6 months, we've been at it for almost 6 months now, is it? You think that's too short when you say they are in a hurry?
I haven't said that the time is too short or too long. I'm saying that in the specific reference to the reception of the address, if a request that comes and is unreasonable, particularly given the feedback that we have received from Mr. Awuah, right, to rush to file, present your report, for me, is very, very, very unfortunate.
What would you say to those who say, well, if you take the issue or your case as seriously as you ought to, you shouldn't be found wanting, to meet a deadline. You should actually work to beat the deadline.
My brother, given the gamut of evidence that have been disclosed, to have been produced before the committee, given the number of witnesses, I think that it will be. It's not something which is not expected. It's expected that lawyers or barristers will always ask for extension of time in the circumstance of this nature, particularly also given the grievous nature of the matter at hand. Look, this is a matter involving the removal of the Chief Justice.
In fact, the committee said that they received about 10,000 pages of documentary exhibits from both sides.
So, if somebody asks for extension of time, I don't think it is out of place. But
does it also matter, or it doesn't matter to you, that when you file such addresses, you know, according to law, the address is actually not mandatory, and whatever you put in the address is not also binding on the judges.
It aids the court in coming to its decision.
That's right.
And if it was not necessary, we would have scrapped it. It is put there to tell you that if you don't file, the court can go ahead to make a decision. However, given the controversial nature of this matter, you want to put it beyond reproach, beyond blemish. As it stands now, it's one of the things that we are going to point to as contributing to the injustice or the unfairness of the process. Look, my brother, the other issue that you raised pertaining to why the committee presented a report on one of the petitions instead of completing with the hearing in respect of the two other petitions. In my view, the failure to do that has not only rendered an unfairness or injustice to the parties that filed the petition, but the Chief Justice, because those allegations will continue to hang around her neck without having the opportunity to prove that they were not true. And so this approach by the committee has also unfairly versed the...
So a very quick one before I go to Mame Mensah Bonsu. Yes, they had 13 witnesses for one side, 12 witnesses for the other side. They had 10,000 documentary exhibits altogether, which makes it a lot. I can't imagine myself as a lawyer having to go through such load to write, you know, an address. But some will argue that sometimes you and I know by our practice, as the case is going on, you should be gathering your address. You will be getting each of the record of proceedings. After the close of each day, you get a record, and then you start writing bit by bit and so on and so forth. But my substantive question is this. How do these two events, not waiting or granting an extension of time to receive the address, to use it to factor into their decision, and also presenting a separate decision, how do these change call them the admitted facts? So that, for example, on the travel expense, the Chief Justice does not deny that this happened, that she took the money, that she went with the husband, that she went with the daughter, and that per diems were paid, and that she retired unimpressed of 6,000 plus or so. If the decision is that this was wrong, this was unlawful, this was unconstitutional, how does giving extra time or presenting a composite report change it?
Whether or not it is wrong is one level, and it is distinct from whether or not it meets the constitutional threshold for the removal of the CJ under Article 1461 of the Constitution. They are two distinct. We need to appreciate that not every error or, if you like, offense or happening may meet that constitutional threshold. Otherwise, every flimsy thing may lead to the removal of the Chief Justice. That's it. You see, this whole matter, we are talking about, I hear Oliver make reference to petition. This is where the error started from. The error started from the wrong foundation. The president receives a petition.
Okay, Nana, please pardon me. Please pardon me. Hold on. I want to do something. No, hold on. We'll go there shortly. Mami,